rights. How many of you know this or heard about this? Trademarks. Okay. What do you know, sir? In fact, I am. Your good name, sir.
Anand.
Yes, please.
IP is some output that has come from a company, for example, that involves some amount of innovative development that they have done, maybe products or technology or something. I don't know how it is to say.
So, it is also this term IP, intellectual property. Intellectual, something which is coming out of our creativity, our brain, right? It's a property. Now, property is nothing but asset, correct? Land, building, company, all this is what property. In those days, every company which was established, asset was a valuable thing. So every company, they wanted a land, they wanted machinery, they wanted building, everything goes in, and that was valued very high. Today, as the world has progressed more and more, we have gone into a digital landscape. In fact, with the pandemic, things have gone, AI has become more and more digitalized. And our Indian government, central government, is also promoting a lot of digital things, and we are all on digital world at the moment. So, asset here, if you look into, is no longer physical assets. It's become your intellectual assets. So that is what is called as intellectual property, right? I would say India is still way behind when compared to European unions, European countries, or America, or any other country if you look into on the IP Act, because they moved far ahead, right? And for all this, there is also all over the world there is something called as the WIPO, World Intellectual Property Organization. You will ask me, why are you talking about WIPO here when we are sitting here? See, you should understand intellectual property rights, these assets are territorial assets. You may be small today, but you may intend to fight for an IP on an international basis. So there are certain treaties which India has signed, and we are part of those treaties which gives you the flexibility one time go to file an application and come to it, right? So you should understand first the nature, the background of IP has evolved, and why IP today is being pushed so much into ourselves, or why people want to have this awareness. Now, if you look into the overview of what I'm going to touch on today is IP and why it's a game changer, right? I'm building a future-proof for IP strategy. This is what I will be talking to you. Why? Auditing and valuing IP. This is very, very important for all of you right from now. And IP assignments and licensing, right? So if you are creating something today on the deep tech or anything, product, process, anything, everything involves a IP. And we generally always advise, even if it's a bootstrap startup or initial stage, I have an idea, I have an innovation. For you, before you even get into any discussion with anybody, we will say, fine, first, even it can be a kit and care, it can be a relations. Fine, first sign an agreement as have everything in place. See, discussions, ideas is where somebody steals your ideas. How many of you agree for that? Initial stage. Your idea you have shared with somebody, but before you made it, they have stolen your idea. So why are you giving it? Even in a discussion stage, as lawyers we say, sign an agreement. It can be a good friend. He's coming. Most of startups come with friends. Funding, correct? Friends, family want to fund yours. But when you're discussing, you're thinking it's based on the IP as such. So imagine if you are building a multi-billion-dollar brand or company, and you see your competitors use your name or product without consent. That's where your IP steps. So if you look into a startup angle, I have had many startups who have come to us, and they would create a good product, they would create a good process, but they wouldn't have got their IPs in place, including the logo, the name. You all will be establishing the KYC norms, ROC compliance, because without that you can't start your business in our country. But IP, mom, we will do it later. Why? Mom, first I have to establish, I need to get my money in place. I know all of us are here doing a business because we need a commercial. But you should understand your brainchild is your IP. And without IP registration or putting the process in place, it's very very difficult for you to establish yourself in the market, right? How am I to differentiate between Amazon and Apple? Their services, they may be online, right? So IP, the brand, you're creating a brand right from now. You may not be immediately Swiggy. How many of us thought Swiggy, something like this would become an IPO tool? We never even thought. Right? So you should understand everything starts small, but when you're starting in your baby stage or initial stage itself, it's important to have your IP. Under the gamut of IP, you should understand is the treasure like you mentioned, ideas, innovations, brand power that sets your companies apart. You can't differentiate between Microsoft, IBM, till they've got their name, their brand, over the years they've built it. And it requires a lot of work from your end if you are the owner of your product or process to build branding. So branding and IP also goes hand in hand. Right? So if you look into the IP umbrella, you have patents, you will have trademarks, you will have copyright and trade secrets, and there is something called also under designs and GI. Okay? Now in patents, it is nothing but your innovations which are unique. It's a blueprint. And your tech breakthroughs. Sometimes when we develop a product or a process, we think in the market mine is the best, or this is very new. For you and for your friends, you think it is new, it is innovative. But you don't know that it's already been registered by somebody else. Right? So you have to do certain searches, which I will take you on the registration course. But let's get this. Not everything can be patentable. It depends upon your area of product, process, what can be patented and not patented. Right? Trademarks. This is very, very important for any company, especially for startups. The name, the way you create your logo, the way you create a tagline. If I say now today, simply love it, what does it mean? McDonald's. Finger licking good, we say. You don't even need to say McDonald's, right? If I just see inverted golden arch anywhere in this world, McDonald's in there. So anywhere if you see or yellow color packing with red and noodles on it, you immediately think it's mine. Right? So that is the power of trademarks. Why I am trying to build this example is for you to understand the power of branding and trademarks. And it doesn't come today you register, tomorrow it doesn't come. It is a continuous work over the years. Why are international brands so powerful? It is continuous work over the years they have built. Right? So that is the power of trademarks and your logo. So it is important that your brand's badge, logo, signature is always captured and you have enough registrations and safeguards done. Right? Next, you look into copyright. What is copyright? See, copyright is more on a creative aspect. I don't know for how many of you on a deep tech it will be. It is more on certain softwares can be copyrightable. Artistic, innovative works, creative works, software code for films generally fall under the category of copyright. Right? Next, if you look into is trade secrets. Now, what are trade secrets? These are like confidential information for any businesses. It can be a process, it can be certain blueprints of business, it can be certain databases which are holding. Those are all trade secrets. I am not going to share every bit of my processing internal aspects to somebody else who's a competitor. That falls under trade secrets. And for trade secrets, we always, classic example, everybody knows is the Coca-Cola's recipe, KFC's recipe, McDonald's recipe. Certain Michelin star chefs have their recipes even copyrighted. Right? So the secrets, the ingredients or the process, all this falls under the gamut of trade secrets. And there is something called as Designs Act. In Designs Act also it is a blueprint of certain machineries or certain designs which you want to. It can be 2D, it can be 3D. All these falls under the Designs Act. GI. I will not put designs in GI because thinking it may not be too applicable for you. GI is nothing but geographical indication. What is geographical indication? It is coming from one particular place. For Kashmir, if it is saffron, it is GI tag. Kanjipuram, famous for what? Patti said, fantastic. So that has a GI tag, isn't it? Exactly. So all of you know this. That GI tag, when it is given to a product or wherever it is, it adds a commercial value higher. So this is what. Yes.
Trade secrets you mentioned. I think like Coca-Cola, only the 2% knows that secret.
Yes.
None of them knows.
Yes.
We have to apply the document to the government.
So it is a process of filing, which I will explain.
When we process the filing, we have to give that formula in that sheet.
Yeah.
Then government also knows that.
Not the government. There is a how you need to safeguard that process. Generally, what happens is it is examination and register. Idhukku vandu pathina trade secrets, you have to have it more safeguarded digital lockers and things like that. There's a separate thing which I will just take you on to one of So this is the entire gamut of what IPR falls under the whole bracket, right? So I've just taken an example which is generally common for everybody to relate, right? So if you look into Coca-Cola as such, the patent aspect here would fall for their bottle cap technology. They were the first in the early years. How many of you, I don't know, there is Gold Spot, there was NASA and all this. But this bottle cap design, Coca-Cola was the first to bring in, where the seals cannot be opened, it was airtight. So that is patented even now, right? Then if you look into their trademarks, it's their brand name and their logo. You don't even need to see a bottle today. If you see red patch with Coca-Cola written, you know who is it, right? That is the power of promoting. Trade secret is your formula and the production methods which are coming in. Designer rights, the shape of this bottle even can be protected, right? For example, on an international scale, again I will tell you this, there is a company called as Tiffany's. Tiffany's into his high-end jewelry and things. They have a teal colored box, teal, aqua blue mirror box. In that box is a particular rectangular shape. That is being given, design rights are there. So even for your packaging, you have certain packaging rights, trademark rights, which comes into your packaging aspects. Copyrights. Packaging and advertising your content for Coca-Cola. Huge millions and billions of dollars are spent on a product or on a process to create a brand. And believe me, it is not the sale of your product and the process which you're going to make your money. I will take it after I get my first billing, after my product reaches certain, because I know a startup, there are budgets. You are hard crunched and this will be your great priority. But this is where you have to start and have it. It is not just, ma'am, a lot of questions come in. Ma'am, we are registering. After we register, what is it? See, we can register. You have to monitor. You have to go to the right professional to take care of the safeguard. If you don't do it now, when will you do it? There are a lot of startups who will develop a BA. And then you have bigger companies who are earning money, who will just absorb you. They will come to you and complete deals. Because for them it is a throwaway price. They are not wasting their energy, their money, their time. Your innovation, your creativity, you did it. But what they will quietly do, come to you, talk to a deal. Your name, your creativity, your logo, nothing will do. They will buy you out. Because they are giants. And for you a startup, I am getting a $1 million deal. Which idiot will say no to it? Is what you will ask. But the point is, you should understand, if that fellow is coming to you to sit and negotiate, your product or your process is so good. That's why he wants you. So why can't you sit to have a good branding and also talk to him on a table? If you're so very interested, you will talk to him where my name, my logo, my identity is also there. It cannot be a white label. Right? I generally don't advise startups to go for a white labeling agreement because the power of you is lost. Then why are you creating all this? Yes, it works. But what is your focus as a business person, your long-standing strategy you want to create in your business? Is it short-term, make my bucks and get out? Yeah, it works. No, I want to showcase myself in this market. I want to drive myself within, say, Tamil Nadu, then internationally or throughout India, then internationally, then it's a long road. So this is your business strategy which each business has to take, right?
Copyright.
Sorry.
Copyright.
Yeah.
It's just a brand.
Sorry?
How do you infringe the trademark and copyright?
See, trademark is a combination of logos and slogans, right? For example, if you look into the Coca-Cola bottle, this is their trademark. Okay? This is the brand. Coca-Cola is the brand. The way the italics are written, it's all been trademark, right? When it comes for advertising content, they have their copyrights. The way it is being written, certain content, right? For example, if I had to say tag, can you just give me Gayatri a quick tagline for a product which everybody knows? We have to look into. That's why I said it requires a gamut of experience to know a person. We should have worked with the patent agent more and more. So we know it, your claims go at one shot and it's given it goes without any. See, that's the first prior art number one. After that is the second, third stage. Yes. Yes, sir? Of course, that's part of a job. We look into. That's why I say it's part of our job. We have to do prior art search. Without doing a prior art search, if you go and just say, yeah, this is patentable, it will get rejected and it will come back. You're wasting money. Correct? For example, the same mundane example it is. Something is paining, you know, hand is paining. You are going to the doctor. Doctor, கவனித்து பார்த்துட்டு ஓகே இங்க ஆபரேஷன் பண்ணணும்னு சொன்னா நீங்க ஒத்துப்பீங்களா? அவர் டயக்னோஸ் பண்ணணும்ல, அது எக்ஸ்ரே எடுங்கன்னு சொல்றாரு. அதெல்லாம் சர்ச் தானே, கரெக்டா கொண்டு வரணும்ல, டெசிஃபர் பண்ணணும்ல. அது எப்படி பண்ணுவீங்க? Unless you have all this step by step. See, it's a huge thing.
Let's say a product has been patented but not in India, in some other country. Can I apply for the patent for the similar product in India?
Provided it's not registered in India, you have to get a consent from them if you're going to. That is licensing and franchising privilege, something over it.
Even though that person doesn't have a patent in India registered, I have to get a consent from them.
It's better, always. It's territorial based. See, there is already something in the market. It is territorial based, right? See, you will have a leverage if you want to use that. Because you will get into an agreement. And you will be able to, see, for example, if products are coming from US to here, a brand is coming, Apple or any international brand you think. Everything is running on licensing agreements, right? Microsoft created a great thing. Today without Microsoft, can anybody function? It's all working on licensing agreements. But he owns the asset. Because he gets paid royalties. Right? That's the power of IP builder. Yes.
Company register பண்றதுக்கு முன்னாடி பேட்டர்ன் அப்ளை பண்ணணும். இந்த பேட்டர்ன் அப்ளை பண்ணிட்டு
இல்ல நீங்க கம்பெனி ரெஜிஸ்டர் நீங்க இனோவேஷன் ப்ராசஸ்ல வந்திருப்பீங்க இல்லையா ஒரு இது பட் இந்த ப்ரையர் ஆர்ட் எல்லாம் பண்ணிட்டு ஃபர்ஸ்ட் பேட்டன்ட்ல இருக்கா பேட்டன்டபிளா இல்லையாங்கிறத ஃபர்ஸ்ட் பார்க்கணும். பேட்டன்டபிளா இருந்தா யூ கேன் ஸ்டார்ட் டு அப்ளை. பட் என்னன்னா அந்த அப்ளை பண்றது உங்க ப்ராசஸும் உங்க ப்ராடக்ட் அப்ளை பண்றீங்க, உங்க கம்பெனி அப்ளை பண்றது இல்ல. கம்பெனி வந்து ட்ரேட்மார்க்ல போயிடும். பேர், the name, the logo, whatever, tagline, அதெல்லாம் ட்ரேட்மார்க்.
ரெண்டு பேட்டர்ன்
பெட்டர்.
நம்ம ஐடியாஸ் பேட்டர்ன் பண்ண முடியும். ஐடியாஸ் பண்ண முடியும்.
ஐடியாஸ் கிட்ட போயிடுவாங்க. நீங்க இப்பதான் நான் கேட்டல ரெண்டு மூணு பேர் டிஸ்கஷன்லயே இருந்துட்டு ஐடியாஸ்
But
cannot
ma'am,
be protected.
Sorry, I'm finished.
It cannot be protected. If you're having an initial discussion or a brainstorming session in a room of strangers or more, have an NDA signed.
Just to his point,
Yeah.
isn't it better to incorporate and then file?
It is, but some of the patenting processes do take time. It's a long
No, in terms of value creation for the company, if somebody wants to buy you
Of
out,
course,
it's better
of
the
course.
patent is for
Of
the
course.
company.
Yes. Yes.
That's my point.
Yes. See, it is again individuals who are going to own the patent. We want a
Yes.
company to
Company
own
to
the
own.
patent. It's something which it's a business decision. A lot of people want the patent for themselves. They don't want the company to own. But in the long term, if you look at, you want your company to go on a global platform, then it is better for the company to own it. But again, somebody has created it. Now those guys who created it, it's your decision whether you want to give them the rights or you don't want to give them the rights, right? So it's your decision. So trademark, as we finish with, patenting after this drafting, it is filing and examination. It will go for filing, process will go. They will check whether legally all your documents are correct. And after examination, if there is no errors, no oppositions whatsoever, it will then go, they will grant and give the maintenance. Generally, patent is for about 20 plus years time, and you have to also pay a maintenance fee. In the 20 plus years in the time, will forget. Because it's a long period. You don't even know when you have to renew it. That's where portfolio management comes in. Because that's the work of us. You look into and we will tell you, hey listen, this is getting. It's same like expiring of things. We will warn you. Apple is registered for technology technology. But there can be Apple which is also registered for clothing and textiles. They run a course. But they can't use the same logo as Apple. It can be something else. And generally, we do trademarks are not allowed on generic terms, which you will relate with the name. Apple, you can't register fruits and say Apple is my name. No, they don't allow generic. Apple is registered today because Apple is dealing with technology, not with Apple as such. You get my point? So those generic things are not allowed. Right? So it's important because there are voluminous millions and billions of logos, names, similar, which are everyday filed. And if somebody will oppose it, if the person is on a vigil, today everybody gets oppositions. You say in this stage itself you get your clearance so that you go through all your stages. We will search and we will tell you. There is something similar, there is high opposition rates, they will oppose you. For example, ITC company, ITC you know right, ITC, has a lot of names, logos filed, even if they don't use it, they priorly file it and keep it. There is a name called patisserie. Patisserie is for pastries and things. They don't use the patisserie much in ITC, but patisserie is filed a long time before. When somebody here locally tried to file the same name patisserie, they came for opposition. File registrations. I am going to maybe do in 3-4 years time, but I will still register this. It is time bound registration. But you should also make use of it. You can't keep it dormant. Right? For that you have to collect certain evidences when we go for filing. Right? All those comes under the checklist. When you are submitting your applications, you will have a checklist of things. Invoices, if you are a company, logo or invoice. Any kind of commercials you have used, marketing materials which you have used. All these will become important for submitting your application. Examinations and publications. If oppositions come, then you will go on course and you will say this is on a different class, it is not similar. Sometimes it is up to the court or the registry to take it. Right? Once that all the clearance is done, the registration and everything else.
And would trademarks get rejected if they sound like, hypothetically, let's say there's a trademark on NEXT, next, and if I file something called NXT, would they are, but it sounds similar? No.
It is, but in India, sound marks are not very, very good. Like, for example, in US, sound marks are recognized. The roar of.
No, I didn't mean the sound. I just meant, let's say there's a company, there's a trademark called Next.
NEXT.
And if I file one saying NXT,
No.
it's not
it again
considered.
Depends upon which class, which
in
service.
the same class, even in the same class, would it get opposed?
It sometimes there
It
are
could
high
be.
chances.
Okay.
Because
Even
it's
if
misleading and confusing.
Oh, so that's the angle.
Yes.
Oh, okay.
So we call it as deception. Deceptively similar. It's confusing.
Okay.
Right? So you're confusing the market players. That they will not allow.
I see.
Like Flipkart. Then there is something called as similar to Flipkart poster card.
Okay.
Card, same color, similar logo, not allowed.
That's the reason why all these companies have like meaningless words as name. Swiggy, Ola, they have no meaning, nothing.
Yeah.
So that's the name we have to find something.
Similarly, like Britannia, actually there is a one A missing in between. Duplicate products also is there in Indian market.
Yes.
So How to find that? Whether they are registering that.
Anything which is on a bigger brand name, brand scale, it's a copy which is counterfeit. It is not right. Authenticity of the product is diluted. நிறைய is getting copied. ஏன்னா நீங்க அவசரத்துல shelf to go and pick up things. If there are two Maggi packets, one says Maggi, one is similar. It's not a Maggi, but same coloring. You think that's Maggi because your mind is so used to the branding. You pick it up and go. Then when you realize it's so deceptively similar or confusing the people in the market, that's not allowed. You have to cease and desist notice and
Not
ask.
allowed, right? But they are registering. The duplicate also registered in India.
Won't be registered. It is to just make money in the
Okay.
market. Confuse you and get your money. Duplicates. Deceptively similar and similar. Nowadays there are a lot of cases. Okay?
And for within the trademark search, we have three software now, IT intelligence software. Only with trademark. Apart from that, we have any other trade software. Like in patent search, we have trade software. Similarly, do we have any trade software?
So generally we do via there are softwares but they're pretty much expensive. It also depends upon where which area you
Is it
want to
okay
do.
if we do with this conventional IP intelligence?
Yes, you can try it. But I wouldn't, it's always good to go for a professional to help you also because they have some insight or input, whether it will work, it may not.
Which one do you prefer now for patent search? Where are search? Which software do you prefer?
I don't
Google patent,
recommend
SaaS, that is okay.
any particular softwares or anything. It is again the discretion of every business owner, it keeps varying.
Say, assume that in our college if they wish to buy some trade software, which one shall I?
I will just let you know on those things. Now when we get
Madam
to
has the
class,
patent for that.
So-
Madam has the patent for that because she's don't want to tell here.
so there are certain classes of trademarks for tech companies which generally falls. You see, class 9 is for software, apps, computers and electronics. Class 42 is software development, hosting services, IT consulting. Class 35 is for advertising, business management, online, retail, key especially for e-commerce industries. Most of you today are on e-commerce, business and online. So this is class 35 or 4. 38 is for telecom and broadcasting if anybody is on that. 41 is education and training. 45 is for legal services, security. For tech companies on cyber security, if you're going into those aspects, it's for them. I think I'm crossing the time they're waiting. So copyright, trade secrets, design filing, this is how the registration process are. One is you have to create and document the requirements, submissions of your applications. If there is any oppositions, you have to be equipped and you will come back. Once it's through, you will have a registration and protection. It's about 60 plus more years. Trade secrets, again, you have to identify, you have to have your validations done. Take enough security measures. Some people in those days had lockers and today it is all digi-lockers. Trade secrets, everything is kept in digi-lockers. You have to also monitor yourselves. You don't go and give it to everybody, right? You have to be very tight on trade secrets and how you can enforce it. Design filing is novelty checking, again, whether it is new, designs are not in the market. There are certain checklists on the application aspects, examinations and publications happen on the gazette, and then you get your registrations and your designs. This I wanted to, can you just tell them a couple of minutes?